agus curum fáilte rivanara. I have to say that I think there are major problems with this legislation. Much has been said already about the flaws in the drafting of the bill, but I think I have to be honest and say that I think this bill is flawed in its delivery, so to speak, or in its execution, but I think that is rooted, I'm sorry to say, partly in the fact that it is flawed in its conception as well. I think it is in places confused, erratic, and I think it would ultimately be counterproductive in terms of shaping good law for our country. It does, I believe, get bogged down in definitional problems that frustrate its own aims, but would also endanger existing rights such as equality before the law, a trial in due course of law, and freedom of expression. For example, the drafters of the bill appear to be unclear whether hate crime is an offence motivated by certain prejudice or simply a perceived attitude of prejudice contributing to an offence. Now, if they mean a perceived attitude of prejudice aggravating an offence, which is what I think the drafters of the bill mean, then they shouldn't be using the term crime, because this will cause no end of confusion. But it seems that the drafters want to treat certain thoughts as criminal if these thoughts are part of the background to an offence, for example, assault. The problem is that this takes us into the area of thought crime. And the bill seems to state that such thought crime has been committed if any person, not necessarily the victim, alleges it, and if the prosecution states it. But there's no reference to any burden of evidence or standard of proof required to establish the thought crime in question. The bill also fails to be precise about which categories of person might be victims of hate crime. In one place, hate crime is defined as including age-related prejudice. But when it comes to the ability of the court to take hate crime into account, offences against victims of age-related prejudice are excluded. So, there's no easy way to say that I am extremely surprised that the bill has come before us in this form. And while we all commend each other's best efforts and sincerity of approach, I do think that we have to bear in mind that people are looking in from outside, and if we bring forward legislation that is, for example, that seems to define hate crime as an offence in the interpretation, and then says an offence is aggravated by hate crime, which is to suggest that an offence is aggravated by an offence, but that second offence is nowhere defined in the legislation. It's going to lead to criticisms of the Seanad. And I think that it is better to deal with these topics by way of a motion, to allow us to tease issues out. And even if a bill then comes forward at the end of that, which some people will accept and some people will reject, well, at least we have to spend less time in kind of teasing it through the issues. And that is my honest opinion on this. I think the bill, as I've said, gets bogged down in definitional problem, but it also jumps the gun. The public consultation by the Department of Justice on hate speech and a review of the Prohibition of Incitement to Hatred Act of '89 is ongoing. And it's my understanding that a separate consultation process is envisaged in relation to hate crimes. So there is the prematurity of the issue. There's also the fact that there is legislation in Britain, as was mentioned by Senator Ward, among others, in sections 145 and 146 of the Criminal Justice Act 2003 in England and Wales. That English legislation doesn't even mention the word hate crime. And yet it's used, that phrase is used 25 times in this short bill. And that worries me, that what has happened here is that a phrase has been taken from political discourse, namely hate crime, and there's an attempt to translate that into a legal concept, instead of doing what Westminster did and trying to tackle the issue directly in a focused way. Legislation is one thing. Public education, the work of our schools, our churches, our NGOs, whoever it is kind of forms ideas and values, is a very different thing from what we eventually craft into legislation. And I don't think that point can be made strongly enough. But let me just address the concept, because I do believe there is idealism behind the idea of trying to attack, if you like, nasty attitudes in our society. I understand what the proponents of the bill are trying to do. It's to send a message that prejudice on the basis of a person's race, religion, sexual orientation, etc. should have no place in human behaviour and no place in Irish society. Excellent. But the legislation doesn't do this. It doesn't create any new category of crime. And we have the reality that judges are able to take circumstances into account when sentencing. So this seems like something that the Sentencing Guidelines Committee of the Judicial Council should be examining and reporting on before we start issuing new legislative edicts to the judiciary. But most of all, I am worried about the concept underlying this bill, which is that there is somehow a hierarchy of victims among people who are equally vulnerable. And that would send entirely the wrong message about crime. So to take an example, imagine two identical cases of assault causing harm. One is committed against an elderly woman. Another is committed against a young member of a community that's an ethnic minority. Now, most people would think that these crimes should receive roughly similar sentences, or perhaps even that the crime against the elderly person might deserve a harsher sentence in certain circumstances. But this bill, I think, would suggest that the crime against the elderly person could theoretically get a fine and a suspended sentence, while the assault against the younger victim would be eligible for the maximum sentence of 5 years in prison. Now, is that justice? Or take, and I say this with great care, the case of a sexual assault against a vulnerable person. Now, a person carries out an assault against a vulnerable person. They do it because they're racist, because that person is a member of an ethnic minority. But perhaps they do it because they have a grudge against the victim's family. Or perhaps they do it because they have a love of violence. We need to be very careful about creating a hierarchy of victims, or a hierarchy of seriousness or odiousness in circumstances like that. And that's where I think talk of hate crime takes us to. Judges must take all sorts of circumstances into account. There may be racism. There may be prejudice based on a person's bodily characteristics, or their sexual orientation, or perceived, or whatever. But it may also be that there are other issues involved. Love of violence, hatred, of some other kind that isn't defined in this bill. We need to be very careful about setting up a hierarchy of victims. I don't think that is good in terms of promoting the right kind of attitudes of respect for every person in our society. The bill, in my view, actually waters down the notion of hate crime, because potentially under its provisions, every crime committed could be a hate crime. Now, others have addressed this. But where the bill defines it as any offence, and here's where the bill defines hate crime as an offence, which a crime should be an offence, but elsewhere it talks about hate crime as somehow the attitude underlying the offence. But my point here is that where it defines hate crime as an offence, it says any offence that's perceived by a victim or any other person. So some officious bystander, so to speak, to borrow a legal phrase from another context, takes a view. Can they be heard in evidence if they believe that the offence in question was wholly or partially motivated by prejudice against a relevant individual? Now, this guarantee, on the face of it, this could mean that all offences in the schedule could be hate crimes, or all offences listed in all circumstances could be seen as hate crimes, because in a country of 5 million people, there'll always be at least one person who holds any particular opinion, no matter how reasonable. Others have addressed the problem around the standard of proof here, and in a way that is one of the most alarming flaws in the bill. It seems to me 4 things are required for an offence to be, finishing up, deemed to be a hate crime. That there is an underlying offence, that somebody perceives it to have been a hate crime, and that the prosecution has to state it in evidence. I've never seen such a weak threshold to be met, or such a low threshold to be met before the imposition of a maximum sentence. I'll conclude with this, and thank you for your indulgence, Lasco Hirley. In DPP versus Cagney and McGrath 2007, the late Justice Hardiman said that the fundamental value that crimes must, spoke of, and I quote, the fundamental value that crimes must be defined with precision and without ambiguity so that the criminal law is certain and specific. This bill, I'm afraid,